Good evening, professionals. We have been discussing on the global corporate laws. In series 1, we are discussing about the Singapore Companies Act provisions. To begin with, we started with how to form a company in Singapore and then to discuss about how to establish the place of business by foreign entities, and then we also discussed about how foreign companies can establish their branches in Singapore. And today we are going to discuss about how directors are governed under Singapore Companies Act. My sincere thanks to Mr. Sundarajan for this presentation. These are the legends used in today's presentation. Act refers to Singapore Companies Act. Registrar is the Registrar of Companies. This is the outline of today's presentation, where we will see the appointment of directors, restriction on appointment of director, disqualification of directors, register of directors, manner of appointment of directors, and what are the provisions with regard to debarment, powers of director, their duties, and how they are removed, and what are the procedural formalities to comply with while they step down from the directorship of a company. Simple provisions to read, understand, interpret, and comply with, friends. We'll begin with how the directors are appointed and what is the minimum statutory requirement as enshrined in section 145 of Singapore Companies Act. As per 145(1), there should be at least one director in a company who is ordinarily resident in Singapore. So what do you mean by ordinarily resident, friends? It means Singapore citizen or PR, Singapore permanent resident, or entry pass holder or employment pass holder. However, please note, friends, EP holder who wants to become a director should get a consent letter from the Ministry of Manpower. Company, like Indian Companies Act, it refers to companies incorporated under the Act or any previous company's return law. Who are eligible to be appointed as directors? It is imperative to know that only natural persons can be appointed as directors who have attained the age of 18. Accordingly, the artificial legal persons like corporates, firms will not be entitled to become a director of a company. We will see now the minimum statutory requirement. If not comply with, what are the ramifications? So, or an application is made by a person that the members appointed to comply with the requirement, statutory requirement, who shall be ordinary resident in Singapore, if he considers it to be in the interest of the company appointment made. Court may on an application of the registrar of person order the members of the company to make appointment if it considers it to be in the interest of company. If members do not follow order or the direction imposed by the registrar, then the members in default shall be liable, and they shall be guilty for this offence with a fine not exceeding 2,000 Singapore dollars, and for continuing offence it is 1,000 Singapore dollars every day during which the default continues. Court again on application of the registrar or other person order the member makes an appointment in the interest of the company. So the provision of section 145 is if you are not complying with the provision of 145 subsection 7 or any direction as may be issued by the registrar, then the court may impose such order as very. The consequences the company faces for non-compliance with this minimum requirement. Very serious ramifications. If company is in business for more than 6 months without having one ordinarily resident director in Singapore, the person who if it is they are compliance, if they are carry on business after the expiry of this minimum cooling off period of 6 months, the member of the company knows that it is carrying on business in this manner, he shall be liable for the payment of all debts of the company which are contracted during this period and may be sued therefore. So it is a serious consequence for non-compliance with this section 145. Having seen the minimum requirement of directors, let's see the restriction on appointment of directors as prescribed in section 146 of Singapore Companies Act. So the conditions to be complied with for an incumbent director are: he shall be a registered qualified individual authorized by him, who shall file with the registrar such declaration that he has consented to act as a director. First, should indicate his willingness to act as a director. Then he shall give a statement in form number 45 stating that he is qualified to act as a director. So the disqualification of director should be proved that he is qualified and eligible to become a director. Point number 3, he shall state that he is not debarred from acting as a director as prescribed in 155B. So we will be seeing in subsequent slides as to what are those disqualifications and what are the requirements for debarring a director. So he has by himself or through a registered qualified individual authorized by him, first he should file a declaration that he takes the minimum number of qualification shares. Then an undertaking that he will take such qualification shares, and also this undertaking is different from the declaration because he is agreeing to make the payment for the qualification shares. And please note friends, this undertaking is equal to the agreement which is signed by way of constitution document agreeing to take the number of shares as done by the subscribers. So that's why it says where a person has undertaken to the registrar to take for the qualification shares, it is in the same position as if he had signed the document, constitution document for those number of shares. Third declaration will be to confirm that he has taken those qualification shares, paid for those shares. Accordingly, his name is getting registered in the register of the members which is being maintained by the company. In case of a company which is formed by way of reconstruction, then what happens? This person or the authorized person shall file with the registrar a declaration that he was a shareholder in that other corporation or in one or more of that corporation of that group, or as a shareholder he will be entitled to receive and has registered in his name such shares not less than the qualification by virtue of such whatever arrangement or agreement relating to such reconstruction. So if the person proposed to be appointed as a director does not qualify with these conditions with regard to qualification, what happens? He shall not be named as a director or proposed director in any document which is being filed with the registrar for the purpose of incorporation or in the register of directors, chief executive officers and secretaries of the company. Whether these conditions will apply to a person proposed to be appointed as a director of any company, it clearly says that other than the provisions relating to consent letter which is being signed, these provisions will not be applicable in the case of company not having share capital. Of course, when the company is itself not having share capital, then you cannot agree to take the minimum number of qualification shares. The private company or where the company has the prospectus or statement in lieu of prospectus which is issued and lodged with the registrar after the expiration of at least 1 year from the date of commencing of business of the company. What if there is a default and complying with this provision of section 146? Company and every officer who is in default shall be guilty of an offence and they shall be liable for a fine not exceeding 10,000 Singapore dollars and also liable for a penalty as may be imposed in this regard. Now let's see the provisions relating to disqualification of directors and debarment of directors. So an individual, when he is declared as an undischarged insolvent, exception being with the leave of the court, with the permission of the court, if he is so declared, or there is a written permission by the official assignee, except in those cases if he is undischarged bankrupt, then he is disqualified to become a director. And he was a director of a company which was wound up because of national security or interest, then he is disqualified for a period of 3 years. And he is convicted of certain offences like dishonesty, fraud, and such offense is more in relation to promotion or management of the company, then he is disqualified for a period of 5 years from the date of release from the prison, or 5 years from the date of this conviction order as imposed by the court. And he shall be disqualified for a period of 3 years when he is convicted of 3 or more filing related offences. Say, for example, some return documents which are required to be filed by the company, and he is in part of the directorship of that company, and such company is violating those norms. Then, for a period of 3 years, if there are 3 or more related offences relating to this filing of returns or documents, and he shall be disqualified for a period of 5 years. This is interesting, friends. So, in not less than 3 companies which were struck off within a period of 5 years, then from the third struck off, he shall be disqualified. So not 4 bases, but only 4 bases. From the last strike off, third strike off, he shall be disqualified for a period of again 5 years. Now we shall read the provisions of debarring a director under section 155B of Singapore Companies Act. There is a reference drawn in the provision for relevant requirements. So what do you mean by relevant requirements? It says the provision which requires any return, account or any other document to be filed or delivered to the registrar. This is relevant requirement of the Act. So what is the effect of issuing a debarment order? Person who has debarment order made against him shall not act as a director of the company except that company of which the person is director immediately before this order being made, or act as a secretary except in respect of those company, that is the company similar to the provision of a director. How long does this debarment continue to be in force? The debarment applies from the date the order is being made and continues until the registrar cancels or suspends the order. Now we will read where the reference is drawn under the provision about the relevant requirements of the Act. Where default in relation to relevant requirement of the Act with regard to filing of returns or document or statement persisted, continued for a period of 3 months or more, and the person was the director or secretary, and the has not this order being issued, sent the director of security, sorry, heard. So the effects of following the debarment order will be the person who is director or secretary after this debarment order is being issued, he shall be guilty of an offence and shall be liable on conviction to a fine not exceeding 10,000 Singapore dollars or imprisonment for a term not exceeding 2 years or with both. We've been discussing about the appointment of director, minimum statutory requirement, disqualification, debarment. Now we will see how they are being appointed. What is the procedural norm? By way of ordinary resolution, or if the constitution document, charter document clearly says that he shall be appointed by such and such mode and manner, the same manner shall be complied with. And procedure for intimating the registrar will be to file the form through the business file website within 14 days from the date of such appointment. Section 173, which deals with register of directors. So the registrar shall maintain the register of directors after getting this particular return, compiling the information about the directors regarding the full name, address, nationality, identification, date of appointment and date of cessation of the appointment. We will see the powers and duties of directors, friends. So they shall be managing the affairs of the company under the direction or supervision of these directors who are being appointed. The company's affairs shall be managed, and the directors will exercise all the powers except those powers which are required to be done by the shareholders in a general meeting. So some of the acts for which shareholders approval will be required are disposal of company's assets, issue of shares, loans, issuance of loans, granting loans and quasi loans to directors. So if you refer what is quasi loan, it says an agreement between two parties where one agrees to pay the other's debt provided the second party agrees to reimburse the first party at a later date, and payment to directors for loss of office. So except for those which are as prescribed in the Act to be clearly done by the shareholders in a general meeting, all other matters could be discussed and approved by the board of directors. Their fiduciary duties are to act, of course, in the best interest of the company to avoid conflict of interest. So they shall certainly act independently without having any pecuniary interest in the company and exercise skill, care and diligence not to misuse their power and information, which is very important. Their statutory duties will be to maintain the records, accounts, hold necessary meetings of the company, appointment of secretaries and statutory auditors, disclosure of their interest. Finally, you will see the procedure for removal and resignation of directors as prescribed in section 152 and section 145 of the Singapore Companies Act. So a person may resign from his office as a director provided resignation procedure is in accordance with the company's constitution, and at least there should be a minimum statutory director who is ordinarily resident in Singapore. And again, like appointment where you have to declare it to the registrar within 14 days, resignation shall also be intimated within 14 days. So with this, we will conclude the fourth part of the Singapore Companies Act to understand and appreciate the provisions regarding the appointment, minimum statutory requirement of directors' appointment, qualification shares to be maintained, and the exemption with regard to qualification shares, powers and duties of directors, removal and resignation of directors. Thank you very much, friends.